Okay, Age Discrimination and Employment Act. So the rest of these that we're going to talk about are all kind of patterned after the Civil Rights Act. Age discrimination is protecting employees who are 40 or older from discrimination. It prohibits mandatory retirement ages, except in some cases like public safety. Airline pilots can have mandatory retirement ages, and it turns out that it's quite young. I don't know if that's because they have a union or not, but it's, I think it's in the 50s. Things like that. And one of the things that attorneys like about this law is that if you can show that the employer was willful in their discrimination against age, like the mandatory retirement ages for that national law firm that we talked about, then you can get double damages. So they can make 2 boat payments with this rather than just 1. They like it. Okay? The other part of this is that you get a jury trial. So in labor law, we like to think about a jury as 11 people who really don't like their job or their boss. And so you're probably not going to fare well if you have to go in front of a jury and show that you were really a good employer, because the cards are already stacked against you. Okay? All right. USERRA, Uniform Services Employment and Reemployment Rights Act. How many of you know someone who is in the military or has served in the military? Yes, almost all of us. This is a way of life in the United States as of the early 2000s. And back in 1994, Congress enacted a statute to help employers remember that they need to support members of the Guard, Reserve, and the active military, all the branches of the active military, because they went from a mandatory draft to an all-volunteer military a few years before that. And employers were bullying their employees into not complying with the expectations of their Guard deployments and things like that, or for their active duty call-ups. They were saying, oh, that's going to be a hardship for us. So Congress, in their wisdom, came up with this law where the employer must accommodate the employees or the applicants' military duties and military assignments. It does require that the employee bring you some of their orders and things like that. You can ask for some documentation. So the employee, you can be assured that the employee is not just making the whole thing up, but pretty much the employer, what we tell our supervisors is if your employee comes to you and is talking to you about this, your response should be, thank you so much for your service, how can I help? Because Congress and the courts take this law really seriously, okay? So the person can be gone cumulatively for up to 5 years, okay? So they can go out for a year deployment, be back for 2 years, go out for another, back, out, back. Or they might do their 2 days, one weekend a month Guard or Reserve deployment, and then their summer 2-week thing, and they might do that for 15 years and finally might get up to their 5 years of overall cumulative. I know at ARUP we don't keep close track on how many years total it's been, and I don't think most employers do. What would that mean to be able to do this without loss of employment opportunity, seniority, pay, or benefits? What does that look like? Any ideas? So I have just been hired. I've been here for 6 months, and I get called up to active duty to go over to Syria now, which is going to be our new battlefield. I'm going to be there for a year, and while I'm gone, the employer has their annual raises. Should I get a raise? Yeah, I see some yeses and some blank stares. Yes, I should get a raise. Really, anything that's kind of time related, I should be able to do. If I've only been there 6 months, but the job I'm in has a mandatory, not a mandatory, but a kind of a time in service raise or a promotion from level 1 to level 2 that happens at 1 year, then 6 months after I'm gone, I should get a promotion. I should come back to that promoted job, okay? Things that it doesn't apply to, so benefits-wise, the things that it doesn't apply to would be things like that are not related to time in service. So, for example, a benefit that's related to how many hours you work or how many dollars you earn wouldn't have to be paid out if you don't work any hours or you don't earn any dollars. Okay? Yes?
What if you have a health benefit?
Health benefits are covered by the military, but the health benefits for the family might continue. So, and you work with the family on that. It's kind of their choice whether they take the military family stuff or they take the employer family stuff. But they're still employed, so they can. Yes?
So after the 5 years, your company can say either quit serving in the military or you're fired?
Legally, you could. Like I said, we don't keep track of it. But if you had documentation that you had granted them the 5 years, you could say, no, we're not going to let, if, you can go on this deployment, but if you go, we're going to replace your job. You could do that. Okay? Any other questions about USERRA? It's an important one. It's going to be with us for a long time. Probably only get more strict as time goes on if employers try to keep finagling around it. Okay? Okay, the Americans with Disabilities Act. This is one that comes up frequent enough that I'll probably spend a little more time on this one. So this law is a good law. Not that the others weren't, but this one has a good heart to it. It requires the employer to make reasonable accommodations to help an applicant or an employee. Again, we've got the two populations, an applicant or an employee who has known physical or mental limitations but is otherwise qualified for the job, and to help them perform the essential functions of the job. Did I remember all the things? I'm doing it by memory because it's behind me, but yes, I got all those pieces in there. And the employer is required to do this unless it creates an undue hardship. We're going to talk about that as we dive into this a little bit deeper. But the basic idea here is not bad. So, because what it requires is that the employer help the employee to perform the job as well as anybody else. Okay? So it's not asking the employer to give up anything. It's just asking the employer to help. Okay? All right, let's get into this just a little bit. So what is the definition of a disability? This has changed in the last few years. This was changed in 2009. So in the court years, that's very young. It hasn't been around for very long. But the definition is that you have a physical or mental impairment that substantially limits one or more major life activities or a major bodily function. We're going to talk about, so this major bodily function is the definition that was added in 2009. We're going to talk about why in just a minute. The second definition, though, is that you have a record of an impairment. So you may not be impaired at all today, but you have a record of being impaired in the past. So I have a history. I had back surgery 7 years ago. Okay? I may not be impaired at all today, physically or mentally, but I have that history. Okay? I apply for the warehousing job that requires you to be able to lift 50 pounds, and they say, no, you can't have that job because you had back surgery 7 years ago. Okay? Can't do that. The third one is a little more difficult to understand. Regarded as. So in this case, the person, the applicant or the employee, is not disabled or impaired at all in any capacity, but the employer treats them as if they are. Okay? And in that case, if they have negative consequences because they're treated as if they're disabled, then they could bring a lawsuit against the employer. Okay? Now, disabilities do not apply to, at least this definition does not apply to temporary or transitory things that are going to last less than 6 months. Okay? It used to be that the definition was less than 9 months. Okay? They wanted to say, and at least I think they were trying to say, pregnancy, we don't see pregnancy as being a disability unless there are complications. When they moved it to 6 months, now pregnancy, maybe that's up for debate. Who knows? But a broken arm, broken leg, those are things that typically wouldn't be considered a disability under this act. Okay? Questions on that? All right. So now let's talk about that first definition. Substantially limited in either a major life activity or a major bodily function. The major life activities cover the things that you're thinking of when you think of disability. You're thinking of people in wheelchairs, people who are blind, people who are deaf, right? Maybe you have some other disabilities that you're thinking of, and those in general are covered here. Include but not limited to caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating. I always like this one, and working. So they're disabled from working because they're substantially limited in working. Okay, how does that work? Never mind. Now the problem with this is that the preamble to this is that they are substantially limited. And what employers were doing in the courts, if the employee would file a lawsuit claiming disability discrimination, the employer would say, well, yes, you have difficulty seeing, but it's not to the level of substantially limiting your life activities. You can see enough that it doesn't substantially limit you. Okay? So they would get into this legal debate about whether you were substantially limited. Here's an example. Let's say your employee comes to you and says, I am HIV positive. Are they disabled? I don't know. Under this definition, probably not. Because right now they have a terrible virus running around in their system, but they're not really limited in, they can go out and do things. They can do stuff still. Okay? It's not until they get farther down that path that they finally can't do things. So what happened was, because employers were getting into this legal debate and very few things, all these cases were getting bogged down in the courts, Congress stepped back in and they said, okay, employers, you guys want to play this game, we will add to the definition of what is a disability. And we're going to talk about bodily functions, including, so this would be the operation of a bodily function, including but not limiting to the immune system. So there's that HIV thing that I talked about. Normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine. So anybody with like diabetes, an employee with diabetes, maybe it's well managed. But see, they're not substantially limited. Well, under this definition, if you have the diagnosis, you would be disabled. Reproductive, and then reproductive functions. Okay. So Congress really turned up the heat on what the definition of a disability is, because they wanted the employers to stop debating whether someone was substantially limited and get down to the business of trying to accommodate their ability to do the job. Remember, the employer has a duty to accommodate a person to help them perform the essential functions of the job. So rather than sit around and debate whether someone's limited or not, let's just sit down and talk about how can we help you get the job done. Okay? That's what they wanted to do. So there are reasonable accommodations and there are unreasonable accommodations. What would be reasonable? So reasonable are things that help someone participate in the application process, help someone have the same productivity or quality standards so they're not making mistakes, and enjoying the same benefits and privileges of employment. Because these people just want a job. They just want to make a living like everybody else. Okay? So that Congress wants us to help them. Employers can choose, so the employer gets to choose from a wide variety of things that could be applied. The employee does not get to dictate what kind of accommodation will happen. They need to talk about what needs to be accomplished in the accommodation, and the employer can choose what the employee says, or they can try other things to see what will be an effective accommodation. And then employers do not have to provide accommodations that pose undue hardships. So we'll come to that in just a bit. Examples of reasonable accommodations. You can read through a bunch of these, things that you might think of. Most of the accommodations that we do over at AREP are really very inexpensive, and actually turn out to be very helpful. One accommodation we did was for an employee who had visual impairment. So he came to us and he said, if you'll just paint a stripe along the first stair and the last stair, then I won't trip and fall, and then you won't have that trip and fall expense that you have to pay for. And so we said, sure, it's going to cost us, $70 worth of paint and a painter's time, and we put these stripes on the stairs, and not only did it help this guy, but all of a sudden our workers' compensation trip and falls in the stairwells plummeted. There were very few people who were falling in the stairwells. Here's what I want to talk to you about, though: reassignment to a vacant position. So if you try to accommodate and it doesn't work, and you try to accommodate and it doesn't work, at some point you have to come to the conclusion that this person is just not qualified to do this job. And if you have tried to accommodate and it doesn't work, then it's okay to say to the applicant or the employee, you're not a qualified person to do this job. But then the analysis for the ADA goes to, well, are there any other vacant positions in your company that I could do? Now, you don't have to create anything for them. You don't have to carve anything out for them. But if you have something open and they feel like they are qualified to do that and are capable of doing that, you have an obligation under this to give them a shot at trying to be successful at it and helping them try to be successful at that new job. Okay? So that's something to keep in mind. Any questions on reasonable accommodations? Sure.
Providing qualified readers or interpreters.
What does that mean? Right?
So if someone doesn't speak a word of English, you're required to have someone who can follow them and interpret everything for them?
Well, we haven't had that play out at ARUP, but we do have qualified readers and interpreters who help our deaf employees. We hire quite a few people who are hearing impaired, and when it comes to having a staff meeting, or if you're having a performance appraisal, or you're counseling them because their performance isn't good, we always have an interpreter there to make sure that they understand everything that's going on in the speaking world. So, yeah. All right? Okay. So what would be unreasonable? First of all, it's unreasonable to lower your quality standards. This is medical laboratory science. We don't have to accept that they're going to make an error on the cross-match of that blood. You don't have to accept that. All right. Lowering productivity standards. If you have a published standard that people need to do so many assays an hour or whatever, then everyone who works for you should be able to do that, including someone who has a disability. Again, the point is that the employer needs to accommodate that person so they can. All right? Lowering conduct standards. If you have an employee with Tourette's and they run around swearing, and you have policies that say that, conduct policies that say that we're not going to swear in the workplace, it's okay to say you're not a qualified person. Okay? These things have all been through the courts. That's why I say that they're unreasonable. They've already been determined to be unreasonable. Carving out part of the job. So that's another one. The typical first response for a supervisor, if I come to my supervisor and I say, okay, so I've had this, I've been in an accident and I now can, I have a permanent, I have a permanent problem with my arm, which is going to make it so that I can't do this piece, this essential function of my job anymore. I can do all the rest of it, but I can't do this piece. The supervisor will typically say, well, we'll just have you do all the other stuff and we'll have other people do that one and we'll all be good, right? Well, that's not really what was intended by the ADA. The ADA was expecting that everyone should be able to perform all of the essential functions of the job. So our task then is to help the newly disabled person to perform all of the essential functions of the job and see if we can accommodate that in some way. Okay, any questions on those? There's a great resource called the Job Accommodation Network, JAN. It's like jan.org or something like that. You can Google it, and they have great ideas on how to accommodate a wide variety of limitations. I think they've published that most of the accommodations that they recommend cost less than like $50 or something like that. It's really kind of cool. All right. Questions on the ADA before we move on to the FMLA?